Hey everybody, this is Candice Carr here, attorney with Ouellette Carr and Spectrum Title Services. And we're going to take a few minutes to talk about riders K and L. And these are the riders to the FAR contract forms. The first one we're going to talk about, K, is the as-is rider. Now, if you know that both sides want an as-is transaction, then the best thing to do is to use the as-is contract form as opposed to using the standard form and attaching the as-is rider. But if you've already started with the standard residential contract FAR form and then you want the transaction to become an as-is transaction, or either side does and both sides agree to that, then you can incorporate this as-is rider K. So we're going to talk about this one, and then we're going to compare it to the next rider, L, which is the right to inspect and right to cancel rider. Okay, so let's get started with this one. So section 1 here, seller's obligations with respect to the property and limitations. Now what this rider does is this, in paragraph A, deletes the repair limits found in the contract form. So it's paragraph 9, A1, A2, and A3, which are the general repair limits, the wood destroying organism limits, and permit limits. So those paragraphs, along with paragraph 11, property maintenance, and paragraph 12, those are all going to be deleted when we're looking at this form here. So there's where it says are deleted. Okay, so moving on to section B. This rider does not relieve the seller's disclosure obligations under paragraph J, which is obviously the seller's disclosure. So except as provided in this rider, the seller has received no written or verbal notice from any entity or agency as to a currently uncorrected building, environmental, or safety code violation. A seller extends and intends no warranty and makes no representations of any type as to the physical condition. So this does not relieve them of the obligation to disclose of any defects that they're aware of, but because it's going to be an as-is transaction, they're not extending any warranties. Paragraph C, or 1C rather, is also going to be standard X in the as-is contract form. So just so you're aware, this paragraph here is also going to be found if you're using just the standard as-is FAR, the same thing is going to be reflected in there. And what this states is that the buyer waives any claims against the seller and any agent involved in the contract for any damage or defects pertaining to the condition of the property that may exist at closing and are subsequently discovered by the buyer. And it does specifically state that the terms of this rider shall survive the closing. Okay, now on to the inspection period and the right to cancel. And here is the only place on this rider where you have a fill in the blank. So the buyer shall have how many days to perform an inspection. If you leave it blank, then it's going to be 15 days. They have 15 days of blank from the effective date within which to have inspections performed, and utilities shall be made available by the seller. So this time frame here is going to be considered your inspection period. Now if the if the buyer determines in their sole discretion, and I'm actually going to skip down to 2C here, if they determine in their sole discretion that the property is not acceptable, then the buyer may terminate the contract by delivering written notice. So this has to be written. This isn't just something you can say over the phone. Written notice to the seller on or before the expiration of the inspection period, stating that they wish to terminate the contract. If they do terminate the contract, then the deposit shall be refunded and releasing the buyer and seller of all further obligations. And then I'm going to go back up to B, because I think that the order of those paragraphs is a little backwards. So we're going to go back up to B. So if the contract is terminated or it doesn't close, then the buyer shall repair all damage to the property resulting from their inspections. Again, this provision shall survive termination of the contract, and you'll find this as well in the FAR as is form. Okay, now we're going to skip down to 2D here. If the buyer elects to proceed with the contract or fails to timely terminate this contract on or before the expiration of the inspection period, which is our date up here, again, that's our inspection period, then except for the seller's continuing as-is maintenance requirement, which we'll talk about in the last paragraph on this form. So except for that as-is maintenance requirement, the buyer waives seller's obligations to make repairs, treatments, close open permits, and accepts the physical condition of the property essentially in as-is condition. So the seller has no obligation to make any repairs if the buyer elects to proceed after their inspection period and the buyer accepts the property in the condition that it's in. Now, except for ordinary wear and tear, the seller does have the duty to maintain the property prior to closing, including but not limited to lawn, shrubbery, and pool, in the condition existing as of the effective date. So this is the as-is maintenance requirement that we just talked about. The seller shall, upon reasonable notice, provide utilities and access to the property for appraisal and inspections, including a walkthrough prior to closing, to confirm that all items of personal property have been removed, all the seller's personal property. Okay, so that's pretty standard in any contract form, but because this is specifically the as-is rider, they're going to add that in there again. Alright, so that's rider K, the as-is. Again, if you know from the get-go you're going to have an as-is transaction, go ahead and use the as-is FAR form. But if you've stuck with the residential contract, the standard contract for sale and purchase form, then you can use this rider. Alright, now we're going to go on to rider L, which is the right to inspect and the right to cancel. Now in lieu, this is paragraph 1 here, in lieu of the inspection period set forth in paragraph 12A, and 12A is going to refer to the base contract form. So in lieu of that inspection period, the buyer shall have, again, this is going to be the only blank to fill in on this one, shall have blank days, if left blank then 15, days from the effective date within which to have the inspections performed, again, and utilities shall be made available by the seller during the right to inspect period. Any inspections permitted under paragraph 12, which buyer desires to make, must be completed during the right to inspect period. So this is, instead of itemizing the different inspections that can be done, this is kind of lumping them all into one, stating you have this many days to perform your inspections, buyer, do all the inspections you want. And again, with 2 and 3, I think the paragraphs are kind of backwards, as I talked about in the previous rider. So in section 3, if the buyer determines in their sole discretion that the property is not acceptable, then they can terminate the contract by delivering written notice. This is the exact same paragraph that we saw in the previous rider. And then back up to paragraph 2, if the contract is terminated or the transaction does not close, again, buyer shall repair any damage that was done to the property as a result of their inspections. Same exact paragraph we saw in the previous rider. Now 4, this is where it's different and specific to this particular rider. If the buyer elects to proceed with the contract or fails to timely terminate the contract on or before the expiration of the right to inspect period, which is our time frame that we saw up here, blank days from the effective date. Okay, sorry about that. Okay, so if they fail to timely terminate or they elect to proceed, then the contract shall remain in effect. And if during the right to inspect period, the buyer has conducted inspections permitted by paragraph 12 and timely reports to seller in writing of those items requiring repair, replacement, treatment, or if they need to close out any permits, then the seller shall be responsible to pay up to those amounts that were listed in the contract in sections 9A, which, if you remember from the previous rider, those were the paragraphs that were specifically deleted because that was going to be an as-is transaction. So now in this one, this is right to inspect, right to cancel. The buyer has the right and their sole discretion to cancel based on inspections, but those repair limits that the seller has agreed to pay still remain in place. So the seller will pay up to those amounts, or if during the inspection period the buyer fails to conduct inspections permitted, or if they fail to conduct the inspections but fail to timely deliver the written notice to the seller, then except for seller's continuing as-is maintenance requirement, the buyer waives any obligations to have the seller repair, replace, or treat anything on the property. So one of those two is going to apply, 4A or 4B. If the contract doesn't close, the buyer shall repair all damage to the property resulting from their inspection, which they've already stated this in section 2. It's kind of a duplicate paragraph there, in my opinion. Okay, so those are your riders K as is and rider L, right to inspect and right to cancel. So I hope you find that useful, and if you have any questions at all about how and when to use these riders, please don't hesitate to email me, Candice at broward-law.com, or you can give me a call. The office number is 954-727-3347. Thank you.